I'm leaning that way, but I'm not leaning all the way.
You're gonna put that on, Yeah.
All right, we now call 26 CR 365, the state of Texas versus Kelvin Alexander Anderson, who's present with his attorney, Mr. Turk, and the state's attorney.
Let's see.
Okay. There is a request for a bond reduction in this case. What is the bond right now?
I believe it's 75,000.
All right. The defendant has been indicted as March 18th of this year by the grand jury. And this alleges that on or about October 29th of 2025, the defendant, one, collaborated with others in carrying on criminal activity, namely intentionally and knowingly committing the offense of illegal possession of methamphetamine, marijuana, and furthermore, with intent to establish, maintain, or participate in a combination or in the profits of a combination consisting of the defendant and others who collaborated in carrying out conspiracy to commit the offense of illegal possession of a controlled substance, namely methamphetamine, and illegal possession of marijuana, possession of a controlled substance, and possession of marijuana and a controlled substance. I'm not sure what that means. They're not. Are they describing methamphetamine? It's just generic. By agreeing with each other, and this is the defendant and three other people, that they would engage in conduct that constituted the offense of illegal possession of drugs. And you and another performed an overt act in pursuance of the agreement by selling and delivering controlled substances. And all of this, according to the grand jury, constitutes the first degree felony of engaging in organized criminal activity. Okay. So, first degree felony that carries with it no less than 5 no more than 99 years confinement in prison or life imprisonment, and a fine up to $10,000 can be assessed. It is a most serious type of violation, and his bond is $75,000.
Yes, sir.
Go ahead.
Will you swear him in? Because I'll ask him a couple of questions. We're just
Raise your right hand. You solemnly swear or affirm any statement you may do during this hearing will be the truth, the whole truth, and nothing but the truth. So help you God.
Yes, sir.
Hold your hand.
And you're Mr. Kelvin Anderson of Park City. Oh.
Sorry, Judge, I didn't know our phone was, volume was up.
So Mr. Kelvin Anderson, as alleged in this current indictment.
Yes, sir.
And just for the court's edification and knowledge, you've been a lifelong resident of Beaumont.
Yes, sir.
Have you ever lived anywhere else?
No, sir.
And currently, I'm an appointed attorney for you.
Yes, sir.
And you're sitting, and he is an indigent client judge, just as appointed, since I'm one of my appointed clients. Are you able to afford personally $75,000?
No, sir.
Have you tried to work it out with family members who are not involved with this on how to make that $75,000?
Yes, sir.
Were they able to pull anything together?
No, sir.
Okay. Where you've been in jail since you were arrested for this?
Yes, sir.
Where did you live at the time of your arrest?
I stayed over there with my mom because she had 12 strokes, so I had to move back in with her. But I did stay at the Long Street address.
So if you got out, where would you be going?
1893 Mall.
Who lives there?
My grandmother.
Is she involved in this case at all?
No, sir.
Does she have any criminal history?
No, sir.
And if you were to get out of jail on bond, would you limit your access to your family who were involved?
Yes, sir.
Would you be willing to wear a GPS monitor?
Yes, sir.
Would you be willing to take drug tests?
Yes, sir.
Would you be willing to have a curfew?
Yes, sir.
Basically, would you be willing to do whatever the court is willing to say, hey, as a bond condition to get the bond?
Yes, sir.
Do you have any criminal history? Have you ever been convicted of a crime?
Besides traffic tickets, but I don't think, no, sir.
Okay. And he doesn't have a violent history, judge. This is not a violent crime. It's all drugs. And it's a first degree simply because it's been enhanced under the organized crime statute. So while the severity of it is first degree, it's not I wouldn't say a true first degree, but a pure first degree. You were arrested on a traffic stop, correct?
Yes, sir.
Not at the Euclid address?
Yes, sir.
Judge, since he has no criminal history, we think that the $75,000 bond is disproportionate to his current.
He came to court hoping to get his $75,000 bond reduced. But once the judge heard about the suspected methamphetamine, alleged drug deliveries, and organized criminal activity, the request took a completely different turn. And the judge's final decision was clear.
Status, and it would probably be best if we could get that reduced so that he can actually get out. It'd probably be helpful for me to help him work on the case, so that I don't have to keep going to the jail to visit him with this voluminous amount of discovery that's in this case. We could actually set up an office call and work through it that way. But Mr. Anderson is indigent. He's just unable to afford the $75,000. It's his inability to pay that bond that's basically keeping him in. So if the court would reduce it to a lesser amount, so that Mr. Anderson had a reasonable opportunity to make this bond.
Anything else?
No, Judge.
Okay. Go ahead, State of Texas.
Judge, looking at the probable cause, the amount of drugs that were found, looking at the amount of methamphetamine of over 400 and something grams, it may have been a first degree just based upon its own, but I haven't got the lab testing back yet to actually verify that weight. But I think $75,000 on a first degree felony is really light, but especially when they're out running around dealing that amount of drugs in the neighborhoods and in our streets. So we would ask the bond to stay about where it's at. And if you do reduce it, or you do decide to do something with the bond, then you have a GPS and home confinement.
Okay. Anything else? No. Oh. What we have is the grand jury has indicted the defendant for a crime carrying with it up to life in prison. It's a serious offense. Not only is it just illegal possession of controlled substances, the defendant is charged with engaging in organized criminal activity, and others have, according to the grand jury, would collaborated on carrying out criminal activity, namely committing the offense of illegal possession of methamphetamine and marijuana. And that's, I believe, being described as synthetic marijuana here. And that you, in the course of collaborating together in a conspiracy, according to paragraph 2, to commit narcotics violations, you agreed to sell and deliver controlled substances. And the probable cause affidavit, which is reviewed, and also the court would note the defendant here in the public safety report doesn't
That's not a bad idea.
showing the offense that is indicted here, but also there is an arrest date of 12/12/25. Was that? Okay, I see. Where he was charged with illegal possession of marijuana. It was a class B misdemeanor. All right. So, based upon a search warrant that was handed out to the law enforcement on or about October 25th of last year, they searched 1492 Euclid's Street, along with assistance by the SWAT team, and several people were observed in the house and detained. And let's see, 122.7 grams of synthetic marijuana, 468 grams of suspected methamphetamine, 11.4 ounces of marijuana, 2 firearms, and multiple identifying documents belonging to Leslie Anderson were inside the home. Are you related to Leslie Anderson?
Yes, sir. That's my brother.
And what about Charisma Anderson?
That's my mother.
Okay. This house here at 1492 Euclid Street, who lived there?
That was my mama.
Your mother did.
Yes, sir.
Okay. Looks like a lot of drugs were at that house. What happened to the mother? Is she
They're all
indicted?
charges.
Oh. Subsequent to that, the police stopped. I guess you had arrived at 1492 Euclid,
There was a second search warrant, I think, on that one.
and yeah, it was on 12/12.
Yeah.
December 12th of last year, and they're keeping an eye on the place. and they stopped you for a traffic violation. 3 people, including you, were in the car. Synthetic marijuana was observed inside the vehicle in plain view. And apparently you were seated behind the driver. Upon exiting the vehicle, police observed a clear plastic bag containing green leafy substances protruding from your left front pocket. And this was recognized to be synthetic marijuana. You were placed under arrest and then found in possession of 3 individually wrapped bags of suspected synthetic marijuana. And then a search warrant of your cell phone was completed after they took possession of the cell phone, and numerous messages indicated you were taking illegal drug orders by way of text messages and delivering the drugs or sending people to your mother's house to get the illegal drugs. And it goes to state that it is evidence that you participated in the organization which turned into delivering illegal narcotics to persons. And let's see, you were supported by the fact that you arrived at the Euclid the morning of the second search warrant and were stopped leaving that location, and several individually wrapped bags of synthetic marijuana were discovered in a vehicle with you. I believe this was, according to Officer Anderson, picking up suspected synthetic marijuana and delivering them to others. All right, so grand jury deems that you engaged in this organized criminal activity by your participation, as the probable cause affidavit states. And there's one thing, of course, to illegally possess drugs. Then there's another higher level where it becomes an organized activity where there is a drug house and it is the distribution method, which you, according to this, were part of. You may be using them, but it's not the possession. That's the key here, is the collaborating with others to run a drug system, a legal drug system here in the city, which is rated a higher degree of seriousness, this being a first degree felony. So you're looking at up to life in prison. Anything else anybody wants to add?
No.
Anything?
No, Judge.
Nothing coming. Even though the defendant's criminal history is not evident here at all, nonetheless, his involvement in what looks like a family plan of making and delivering drugs in this city and helping turn this city into an organized criminal location for getting your drugs is about as serious as it gets under Controlled Substances Act violations. This court finds $75,000 bond is not unreasonable under these circumstances. If you post a bond, you must have a drug patch and GPS device, and you will be at home confinement, wherever that is, but not at these locations at Euclid, 1492 Euclid. And you can only leave to and from your home in the most direct route possible for the same exceptions that the court gives in all cases, to and from work if you're employed other than drug manufacturing and dealing, that this is the only thing they say about you. I don't know what else you do. And then